Well, I know that law students spend a lot of time preparing for this tournament, developing their ability to spot an objection when a question is asked by the other team of a witness on direct or cross-examination. So in this segment of our video course, I have developed a whole series of questions on direct examination. Some of them are objectionable, others you should be able to see are fine and not objectionable. After each question, I want you to stop the video, make an objection if you think one is appropriate, and then we'll talk about whether the objection is appropriate or whether it's not an objectionable question. I urge you to work out loud. Don't work silently in this portion of the video. Talk right at the screen. Talk to me. Make an objection. Raise your voice. Let me give you a little background of the factual context in which the questions will be related. This involves a contract dispute, a 2-week rental of a luxury house on the seaside. There has been storm damage to the entire area, including the properties surrounding the rental house, and the renter was surprised when he or she arrived at the location for an important family reunion. The renter cancels the contract, claims breach, and seeks return of a rental payment in excess of $40,000, a serious contract dispute. There are catering cancellation fees and costs related to the arbitration being sought by the claimant. So the claimant renter is conducting, the counsel for the claimant is conducting direct examination of the primary witness, who is the renter himself or herself, and you represent the Airbnb type business that is the listing organization for the rental property. Here's an important rule that applies to this tournament, and I've actually seen teams get tripped up by not understanding this rule. You will be conducting the cross-examination of this witness, so you are the only one who can object during the other side's direct examination of the witness. It gets a little confusing because of the order in which these events occur, but it is important to understand that only one lawyer at a time may be involved with a particular witness, either for a cross-examination or lodging objections to questions that are asked of the witness by the other side on direct. Okay, so here's your first question. Can you tell us what you saw in the front yard the morning you arrived? I'll repeat the question. Ms. Witness, can you tell us what you saw in the front yard the morning you arrived? Objection? Well, there's no objection appropriate here. This is an open question. It calls forth a single fact, and it's well structured. In fact, it begins with the word what. So, no objection. Here's your next question. Question of the witness. Do you think that if there had been no storm-damaged trees in the yard, you would have still canceled the contract? I'll ask it again. Do you think that if there had been no storm-damaged trees in the yard, you would have still canceled the contract? What do you think? Would you lodge an objection? Absolutely. Objection. Leading the witness and calls for speculation. It's objectionable on 2 grounds. And this is a classic poorly formed question for tournament play. It asks the witness to speculate on hypothetical facts, and these have no place in a civil hearing. It's also a leading question, clearly conveying the answer that the questioner is after. Here's your next question. Do you think you acted in a reasonable manner when you canceled the contract? Objection. Calls for a legal conclusion. You bet this is objectionable. Never ask a witness for an opinion regarding whether an action taken is considered by that witness to be reasonable. As law students know from first-year torts and contracts, this is an important objective standard that is to be determined by the finder of fact and is really inappropriate to ask of a fact witness. Here's your next question. What did your cousin say about the severely damaged walkway that you had to take down to the beach? I'll ask the question again. What did your cousin say about the severely damaged walkway down to the beach? Would you raise an objection? Objection, you bet. Calls for hearsay, and it's a leading question. Whenever you ask a question that asks the witness to relay a verbal comment made by someone outside of the hearing, it may draw a hearsay objection, so be ready to defend the question. It's a leading question because the suggestion that the walkway was, quote, severely damaged. Using phrases that cue the witness or put words in the witness's mouth will always be considered a leading question. Here's your next question. Miss Witness, what did you see when you arrived at the beach? Objection? Well, there's no objection to be made here. It's an open question. It calls for the witness to relay firsthand information. What did you see when you arrived at the beach? It begins with the word what. It's pretty hard for a question beginning, what did you see, to become an objectionable or a leading question. And it's specific as to time. It's when you arrived at the beach. So, good question. No objection. Here's your next question. Ms. Witness, tell us more about the chainsaw noise you heard that morning and what your cousin did about the caterer's delivery of breakfast. Objection? Let me repeat the question. Tell us more about the chainsaw noise that you heard that morning and what your cousin did about the caterer's delivery of breakfast. Objection? Well, yes, it's a compound question. Can you see how this question is objectionable? Common sense tells you that a full answer would address one part of the question and then the other on a completely different topic, talking about the delivery by the caterer. So a compound question, simply rephrase. If you are the questioner, be prepared to rephrase, break it down into its single components. Here's your next question. Ms. Witness, were you aware of the... Well, let me restate that. Ms. Witness, you were aware of the January storm, weren't you? I'll repeat it. You were aware of the January storm, weren't you? Is that objectionable? Well, yes, it's a leading question. It's also objectionably vague as to the time of this witness becoming aware of a fact. It's a leading question. It suggests to the witness what answer the questioner is looking for. Here's your next question. It's a restatement of the last question. When did you first learn about the storm that occurred in early January? I'll repeat it. When did you first learn about the storm that occurred in early January? Objection? No, I think there's no objection to be made here. Let's move on to the next question. When you confirmed the reservation on January 28th, did you know about the storm that hit the island in early January? How about that question? Let me repeat it. When you confirmed the reservation on January 28th, did you know about the storm that had hit the island in early January? Objection? Yes, it's leading the witness. This is actually a close one, and you may get overruled by the arbitrator. I would urge you to make the objection anyway. Here's your next question. How did your cousins feel about your canceling the beach house rental? I'll repeat it. How did your cousins feel about your canceling the beach house rental? How about that question? Objectionable? Absolutely. And your objection is that it calls for speculation on the witness's part. How would he or she know what was in the minds of the cousins? So it's a poorly formed question. Here's your next question. Did your cousins say anything to you about the condition of the beach house? I'll repeat it. Did your cousins say anything to you about the condition of the beach house? Would you make an objection? Well, you may make a hearsay objection just to see how your opponents handle the exception. It's not hearsay, remember, if it's offered to show the fact that the witness's cousins teased him or her about the condition of the beach house. Here's your next question. Tell us what it was like to grow up in a family like yours. I'll repeat it. Tell us what it was like to grow up in a family like yours. How about that? Objection? Yes? Objection. It calls for a narrative response and it is irrelevant to any of the issues involved in the case. Calls for a narrative response and irrelevant. Here's your next question. How did you manage to get to the beach? I'll repeat it. How did you manage to get to the beach? Objection? Yes. I think this question is vague. I have no idea what manage means in this context and is vaguely leading the witness to tell the witness to suggest it was difficult to manage to travel to the beach. You may get an argument on this. It's an easy question to rephrase. You say to the panel, I'm happy to rephrase the question. Tell us about your walk to the beach. Now that is an open question and unobjectionable. So here's your next question. Was it difficult for you to walk to the beach across the neighbor's property? Was it difficult for you to walk to the beach across the neighbor's property? How about that? Objection? Yes, leading. It's a leading question. It's the characterization difficult in the question is leading because it suggests to the witness the answer that you're after. You want the witness to testify that it was difficult to walk across the neighbor's property. It's an easy question to rephrase. I'd rephrase it along these lines. Tell us about your use of the path through the neighbor's property. An open question and lets the witness deliver the information that you're after. Here's your next question. How did your cousins feel about the walk to the beach? How did your cousins feel about the walk to the beach? Objection? Well, yes, it calls for speculation. We've seen similar questions in the past. Let's rephrase this question. Did your cousins tease you about the condition of the house? Assume the answer would be yes. What did they say? Not hearsay because it's not offered for the truth of the cousin's statements, but to show the fact of teasing as motivation for the renter's actions. Let's move on to the next question. Did you observe whether any of your cousins had difficulty on the walk to the beach? Did you observe whether any of your cousins had difficulty on the walk to the beach? Would you object to that question? Well, I think there's a possible objection here as a leading question, using the word difficult again. It is forecasting to the witness the answer that you are seeking. So, restate the question. What did you observe of your cousins on their walk to the beach? That removes the problem. Let's look at the next question. Tell us about the condition of the beach path. Tell us about the condition of the beach path. Objection? Well, no objection here. But let's suppose this. What if the witness answers, well, I was particularly worried about my Aunt Betty, who recently had a stroke and may not be able to negotiate the rocks I saw on the path. And then I told... You're getting an answer that is not responsive to your question. And you can object to the arbitration panel and assert that the witness is not being responsive to the question that you asked. How about this question? Would you agree with the National Weather Service that the storm was actually a Category 2 hurricane? Let me repeat this beaut of a question. Would you agree with the National Weather Service that the storm was actually a Category 2 hurricane? So what do you think? Would you lodge an objection? Well, I like to think of this, and it took me a few minutes to write it, as a rare four-way objection. This is objectionable on four grounds. First, it's a leading question. Second, it assumes facts not in evidence. We can assume that no weather data had been offered in previous testimony. 3, it calls for a conclusion on the witness's part. And 4, it calls for an opinion, an expert opinion, and this witness is not qualified as a weather expert. That's a four-way objection. Leading question, facts not in evidence, calls for a conclusion, and it calls for an expert opinion. Well, let's revise the question a bit. What if it reads now, would you be surprised if I told you that this storm was a Category 2 hurricane? Would you be surprised if I told you that this storm was a Category 2 hurricane? Objection? Well, I think yes. Objection. It is still a leading question. This form of question might be fine on cross-examination, but it's not going to work well on direct. Let's look at this question. What did you read, if anything, in the Port Adair papers or online about the January storm? What did you read in the Port Adair papers or online, if anything, about the January storm? Objection? No, I think no objection here, although the question is a bit vague about when the witness might have read this information, but I think I would lodge no objection. Well, that wraps up the Spot the Objection series that we've put together, and I hope you found it helpful. Next, we're going to move on to designing your cross-examination.